Okay, we might make a start. I'll just acknowledge the traditional owners of the land on which I'm meeting you all from. I'm on the land of the Wathaurong people, just outside Ballarat in Victoria. And I'd like to pay my respects to elders past and present and acknowledge this land was never ceded. My name's Sari Baird, and I'm a board member of the Charity Law Association of Australia and New Zealand, and I'll be chairing today's webinar Key Cases series, the first we've got for the year, and we do have over 100 people registered for this event, so we're obviously very pleased that we've got the generous time and knowledge of the speakers who've drawn you all to this session. My happy duty is to introduce you to the speakers, and pardon me if I'm looking away from the camera. My little bios are on the screen to my right, but our first speaker will be Caleb Simmons, who's joining us from Prolegis in Western Australia. Caleb is an associate with Prolegis lawyers. He assists clients with disputes and regulatory investigations and advises on the establishment and governance of charities. Our second speaker, Rebecca Lambert-Smith from Moores Legal. Rebecca is a practice leader in the corporate advisory team and heads up the charity and not-for-profit law team at Moores. She's also a member of the Law Council of Australia's Charities and Not-for-Profits Committee. Our third speaker is probably well known and a frequent flyer on our case series, Professor Myles McGregor-Lowndes, OAM. Myles is the former director of the Australian Centre of Philanthropy and Not-for-Profit Studies at QUT. He's also a member of the ACNC Advisory Board and the Law Council of Australia's Charity and Not-for-Profits Committee. We're going to have each speaker address two cases, and without further ado, because we do have 15 cases, two cases each, 6 cases to get through, I'll hand over to Caleb and stop sharing my screen so that Caleb has access.
Thank you.
Sorry, just while you're doing that, Caleb, just one question for everybody, or comment for everybody. We will take Q&A at the end of the 3 speakers, so perhaps if you pop your Q&A in the chat, because we do have so many attending, and I can see your slide, just confirming that, Caleb, because we do have so many attending, it's going to be hard to monitor hands, but if you could pop any questions in the chat, I'll monitor those. Thank you. And over to you, Caleb.
Thank you, Sari. I would also like to start by acknowledging the Whadjuk people of the Noongar Nation as the traditional custodians of the land that I'm presenting from today, and I pay my respects to their elders, past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples with us today. The cases we'll look at reflect 2 pressing issues for charities and how the regulators of charities might approach those issues. The first case is a decision of then Justice Stein, now Chief Justice Stein of the Supreme Court of South Australia, which concerned the remuneration of trustees of a statutory trust. The background to this matter is that the applicant was established as a trust in 1892 under the will of Jessie Brown in honour of her late husband, James Brown. The terms of the trust were to found and endow an institution in the name of James Brown for the benefit of those who were destitute, aged, afflicted, or for the deserving poor. In 1894, the James Brown Memorial Trust Incorporation Act was enacted to provide for the incorporation of the trust and to prescribe the powers and functions of that trust. And then again in 1990, the James Brown Incorporation Act 1990 restated the purposes of that trust and revised its powers and functions. Scheduled to that act was a declaration of trust which set out the trust purposes and powers. At the time of the application, the trust was a registered charity. It owned and operated a range of residential care facilities and retirement villages, including the one on the slide, and had net assets of about $117 million and employed close to 600 people. The work that was required to oversee such a substantial, complex operation caused the trustees to seek clarity from the court on 2 questions. Did the trust have power to remunerate its trustees? And if so, was the remuneration scheme proposed to the court reasonable? The application was brought in part under Section 5 of the 1990 Act, which allowed for the trustees to apply to the Supreme Court for advice or direction as to any matter connected with the management or administration of the trust property. In relation to the first question, the court stated at paras 18 and 19 that the power to remunerate the power to provide remuneration to trustees was incidental and implied within the powers that were already present in the Declaration of Trust. Justice Stein also considered that the complexity of the trust's operations, its regulatory environment, and the need to attract candidates with sufficient skill supported her proposition that the payment of remuneration was expedient for the fulfilment of the purposes of the trust. In relation to the second question, the trustees put forward a set of remuneration rates. The rates were based on a survey the trustees conducted of similar providers and also a report produced by McGurk Consultants. Those rates were to be increased yearly based on the percentage increase determined by the Fair Work Commission's annual wage review decision, and also were to be subject to intermittent market rate reviews. The proposal was approved by the court, which noted at para 22 that given the assets of the trust, the complexity of trust operations and their size, I accept that the trust position on remuneration of trustees is reasonable and consistent with the best interests of the trust. Taking into account the information published in the McGurk report and the filed material, I consider the proposed remuneration is reasonable. Make a couple of observations about this short case. The first is the importance of having some objective basis for remuneration rates. Whether proposed remuneration is reasonable can be a difficult matter to assess. Criteria like net assets, numbers of employees, regulatory environment are relevant, but do not need neatly to a particular number which might be considered reasonable remuneration. For the applicant, the McGurk report was critical. It broke down the median and average remuneration to directors of not-for-profit aged care providers, and all of the applicant's proposed rates of remuneration were below both the average and the median within the same sector, and in some cases well below equivalent providers, making it easier for the applicant to demonstrate reasonableness. It was also well below the average of for-profit counterparts. The ACNC's guidance states that whether a charity remunerates its directors is up to the charity, but a charity that remunerates should be able to justify payments in the context of it pursuing its charitable purpose and should consider how the payments will be determined. I would expect that where remuneration exceeds what might be considered reasonable and there's no written framework to determine remuneration amounts, one might expect the ACNC to ask questions related to the pursuit of purpose, financial management, private benefit, and applying assets and income for their requisite purpose. My second observation is the curious role of the Attorney General in these proceedings. Section 10 of the 1990 Act, which provided for the declaration of the trust for the applicant, included an ability for the applicant to amend the trust deed with the approval of the Attorney General. If the charity was a company limited by guarantee and unsure whether it had the power to remunerate its directors, it would simply just amend its governing rules to make it clear. One wonders whether the applicant did make such an appeal to the Attorney General to include an explicit power to remunerate its trustees, and if so, whether the Attorney General was resistant on the basis of outdated views of remunerating charity trustees. It's likewise curious that the Attorney General's view on the application generally was only communicated to the court a whole year after the matter had already been heard. So what posture the Attorney General took might not ever be known to us, but the overlapping regulators and supervisors of charities and their idiosyncratic approaches to pressing issues is enough to make me think that perhaps something more was happening behind the scenes. I'll move on now to the second case, which concerns an appeal against an order from the Charity Commission for England and Wales to disqualify one Gary Mond from being a charity trustee. What invoked the ire of the Commission Well, Mr. Mond was a trustee of 5 charities that each had purposes related to the promotion of Jewish thought and relations. Between September 2014 and October 2021, Mr. Mond liked or commented on 5 social media posts in a manner which the Commission considered were able to be interpreted as Islamophobic. Those interactions included liking 2 posts from an American political commentator who had been barred from entering UK based on her views being likely to cause division, and 3 comments on different posts, generally each of a political nature, but all which included comments about those of the Islamic faith. Eventually, there was public reporting on the last of those comments, which led to Mr. Mond issuing an apology and also resigning from his various trusteeships, and then the Charity Commission investigating. Section 181A of the Charities Act empowers the Charity Commission to disqualify a person from acting as a trustee in a number of circumstances, including where the person's conduct was or was likely to be damaging to public trust and confidence in charities generally, or particular charities, and where making the disqualification order was desirable to protect public trust and confidence in charities generally or particular charities. The Commission characterised Mr. Mond's social media activity as supporting the posts which he liked, and interpreted Mr. Mond's comments as being divisive and intolerant of others, particularly those of the Islamic faith. The Commission's view was that Mr. Mond was therefore not fit to be a charity trustee because his social media conduct had been damaging or was likely to be damaging to public trust and confidence in charities generally and in the specific charities where he was formerly a trustee. Mr. Mond's evidence to the Commission and then to the tribunal hearing the appeal was that his comments were directed towards particular fundamentalist expressions of Islam or political Islam, and were genuine political comment that received protection under Article 10 of the EU Convention of Rights. Mr. Mond made various other submissions as to why he was fit to be a trustee of the charities that he was a part of. The tribunal allowed Mr. Mond's appeal and set aside the Commission's order. It found that generally, the social media activity did not demonstrate an unfitness. 5 interactions over 7 years was insufficient, and not all interactions were objectionable to the reasonable social media user. And secondly, the making of a disqualification was not in the public interest because it risked setting the standard of conduct for charity trustees too high. 2 paragraphs that give a flavour of the judgment, which is worth the read on the screen, and I'll just read para 92, which is particularly pertinent. If such conduct is found to be a basis for a disqualification order and is applied more generally in the charity sector, it risks setting too high a bar for charity trustees and adversely affecting public trust and confidence in the charity sector by putting off individuals who may be effective trustees in pursuing some part of the full range of charitable objectives permitted by charity law. A few comments on how this fits within the Australian experience. Firstly, the ACNC does have guidance, particularly for small charities, which says improper social media use is capable of engaging the governance standards which all charities, except basic religious charities, must meet. This is probably because of a possible damage to the reputation of a charity, which might reflect a breach of duty of reasonable care and diligence, or a breach of the duty to act in the best interests of a charity. That proposition finds some support in the comments of the tribunal and would also be consistent with general principles, I think, relating to duties of company directors. However, practically, we would not expect the ACNC to behave the same way as the UK Charities Commission. This is firstly because the ACNC's powers are far more limited. The ACNC can only disqualify a person once it has exercised the power to suspend or remove a responsible person from a charity. And the ACNC can only remove or suspend a responsible person in very limited circumstances, which include that the suspension or removal must be necessary to address a contravention or non-compliance with the ACNC Act, the governance standard, or the external conduct standards. There is no general power under the ACNC Act to remove or disqualify a person on grounds of unfitness. Second, the Australian experience is that the ACNC has in fact never reported using its suspension or removal powers, let alone its disqualification powers. One might query whether the preliminary step of issuing a show cause notice intending to exercise that power has been taken, because the ACNC doesn't report on the issuing of show cause notices. But the ACNC statutory mandate generally is to prefer guidance and education unless there are sufficiently serious circumstances to necessitate a stronger course of action. Minor social media infractions are unlikely to justify stronger action other than a letter from the regulator. Now, last and perhaps most meaningfully, I think the case provides a fresh way for thinking about how to protect and maintain public trust and confidence in charities. This is, of course, the first object of the ACNC and something that the Commissioner must have regard to in exercising her powers and functions. Regulatory approaches must be careful not to seek to enforce such a high standard of conduct that no one is able to reach it, or that parts of the sector might be jeopardised or might be unable to comply with it. Regulatory approaches that alienate or jeopardise a broad involvement in the charity sector erode rather than promote public trust and confidence in that sector. There's a little bit of time left for questions, but I think we are going to collate them all at the end and deal with them then. Is that right, Sari?
Yes, thank you, Caleb. That would be great if people can keep their questions till the end, pop them in the chat, and we'll deal with them then. Thank you so much. We're now going to hear from Rebecca Lambert-Smith from Moores. Thanks, Rebecca.
Thank you,
and
Sari.
Just a thanks also to Myles for kindly posting the case information in the chat if you want to have a look at the case. I do have a slide at the end that I could share that will send you straight to the QUT case notes. So thanks, Myles, for that. Thank you, Rebecca.
Thank you, Sari. And it might also be worth mentioning that we will circulate the slides after this session, which should be helpful to you because there's quite a bit of information on mine. So please don't feel like you need to frantically write it all down. I'm presenting to you from the lands of the Wurundjeri people of the Kulin Nation, and I just want to acknowledge their elders past, present and emerging. The first of the cases that I'm speaking to today is the Commissioner of State Revenue against the Montessori Children's Foundation, a Queensland Supreme Court case. And it considered the question of whether or not an entity is an institution. This is another one of those pernicious red tape issues that sees charities subject to overlapping regulation with different interpretations of similar concepts by different regulators in slightly different contexts. Hopefully, the Montessori case has resolved a long-standing concern in Queensland regarding the Queensland Revenue Office adopting an understanding of the term institution that was arguably too narrow with respect to charitable trustees. It is somewhat unfortunate that it needed to go to the Queensland Supreme Court, notwithstanding very good representations by the Queensland Law Society, but so it went. So the Montessori Children's Foundation was the corporate trustee, and it's a company limited by guarantee in its own right, of the Masterson Montessori Indigenous Children's Trust. The trustee, in its capacity as trustee, was registered with the ACNC as a charity, which is really just background because obviously for a state assessment, your ACNC status really doesn't have any impact. The primary object of the trust, as set out in the deed, was to further the education of Indigenous children in the Cape York area. And the activities of the trust included the direct provision of Montessori services and development of a Montessori curriculum. And if you read the case, you'll see that the activities of the trust actually evolved over time, and ultimately the case was decided on the post-29 activities. So there was some consideration that prior to, I should say, 2019, there was some consideration that prior to 2019, the activities of the trust were perhaps too passive, but we may come back to that. The trust purchased 3 properties in CLAANZ to generate business income, and it signed transfers on 24 November 2020. And obviously, the purpose of its application to the Queensland Revenue Office for registration as a charitable institution was in order to avoid stamp duty on those transactions. So they did, in fact, apply for registration as a charitable institution under the Taxation Administration Act, and they did so under the category of public benevolent institution, which then required the SRO, or the Queensland Revenue Office, to determine that they were an institution. The other relevant section of that act that is discussed in the case a little relates to 149C subsections 5 and 6, which talk about the requirement to have specific terms in the constitution of the applicant, that it be not-for-profit, essentially. And what's interesting is subsection 6 states that a constitution includes a law, deed, or other instrument that constitutes the institution, which the court subsequently referred to as well. The initial application was refused by the Commissioner of State Revenue, who found that although the trust was charitable, it lacked the essential features of an institution because there was no body or organisation independent of the trustee set up to carry on activities or provide services relevant to the purposes of the trust. The trustee appealed to QCAT, and in that forum was successful, where it was held that the trustee was more than just a mere trust, and instead it was a body existing to translate the purpose into its living and active principle. This took the trust beyond something that was a mere trust and to the level of being an institution. On appeal to the Queensland Supreme Court, there were 4 grounds of appeal. The first was that the QCAT had failed to interpret and apply the statutory term institution in accordance with its technical legal meaning. The second and third were essentially that even once you know the meaning, that it had been misapplied to this trust, including consideration of its structure, the number of members that the trust had, and its activities. And then the fourth was an error of law suggesting that there'd been inappropriate regard to matters that occurred after the relevant date, being the transfer date of the properties. The justices in the case found as follows in relation to those 4 grounds. Firstly, in relation to this assertion that there was a misapplication of the technical meaning of the term institution, they said there is no technical meaning of the term institution, and it needs to be considered in the context of the purposes of the legislation and the statutory terms. In this particular context, they said it takes its ordinary meaning, and they referred to and approved of Stratton and Simpson, where Justice Gibbs said, an institution is an establishment, organisation or association instituted for the promotion of some object, especially one of public utility, religious, charitable, educational, etc., being the definition from the shorter Oxford English Dictionary. They also referred approvingly to Mayor, etc. of Manchester against McAdam, where it says an undertaking formed to promote some defined purpose, or a body called into existence to translate the purposes conceived in the mind of the founders into a living and active principle. They said that the authorities did not support the submission that institution denotes more than 7 members or a meaningful number of members. And we do see this coming up in other contexts where the state revenue officers will often with reference to the PAMIS case, say that an institution must look a certain way. It must have a certain relationship or not have members or directors that are too close to each other or too few or too controlled. That was not accepted in this context by the court. They said that they were satisfied that the trustee was required to apply trust property to its charitable objects and did so through substantial activities from 2019 onwards. Although developing curriculum was a preparatory activity, that was okay and was consistent with the direct provision of services. And then finally, they said, yes, there may have been consideration of activities after the transfer date, but it was only in order to understand the activities prior. They also noted in OBITA that where the Taxation Administration Act requires consideration of the constitution of an entity, where you have a corporate trustee and a trust, it's proper to consider both the terms of the constitution and the trust deed, which was helpful in this case because one of those documents had been altered before the relevant date and one altered after the relevant date, but the court was satisfied that it still met the requirements for an institution. So I think what the case shows is, as we know, characterisation of an organisation as an institution turns upon the facts. While merely holding trust assets for charitable purposes will not make you an institution, on that continuum between a passive and an active organisation, you will ultimately cross the line to being a living and active entity that's engaged in direct provision of services. And that may be enough for being an institution, irrespective of the composition of your membership or other factors that the Revenue Office was focused on in this case. The court also noted that it's really important not to forget that a trust is not a separate entity, and there was some unhelpful arguments made in QCAT where they tried to suggest that both the trustee and the trust might be registrable under the Act. The court didn't find it necessary to make a decision on whether that would have been possible, but did flag that they didn't think it would be consistent with the principle that a trust is not a separate legal entity. We keep coming across the institution requirement as not-for-profit and charity practitioners in many different contexts. And so if you apply to the ACNC to set up a public benevolent institution or a health promotion charity, you will need to satisfy the ACNC that you meet the institution requirement. When you seek fringe benefits tax exemption, you will need to, or as a religious institution seek fringe benefits tax exemption, you'll need to satisfy the ATO that you are an institution. And oddly, the ATO will accept the ACNC's determination for a PBI that it is an institution, but does not accept the ACNC's determination for a health promotion charity, at least under the legislation. And then, of course, in each of the state jurisdictions in relation to duties, land tax and payroll tax, there may be institution requirements that apply as well. This means it's possible that an entity that's operating across Australia may need to satisfy the ACNC, the ATO and the state revenue officers in each jurisdiction that it is an institution, and it may encounter a slightly different application of this test with each regulator, which is incredibly unhelpful, and that's notwithstanding some harmonisation provisions that exist in each state. This is an area I think that is really ripe for alignment and similar to fundraising perhaps in that sense. We also see that if you look at the financials for this organisation, they have been waiting since 2020 for approximately $250,000 back from the Queensland Office of State Revenue, which is incredibly unfortunate for a not-for-profit organisation to be put in that position. The Barristers Benevolent Association is the second case that I'm speaking to today. And in this case, we have an unincorporated association, which also happened to be an ACNC registered charity with a PBI subtype. That entity, the Committee of Management of the Unincorporated Association, were trustees of a fund for the objects of the association, which were to afford assistance in necessitous and deserving cases to current and former members of the New South Wales Bar and their dependents. They made an application for judicial advice to the court, asking whether the fund could be used to pay for consultations with counselling professionals, other administrative costs reasonably necessary and incidental for this scheme, which they called bar care, and the employment of the bar care director. So as part of that consideration, the court had to consider, is a person in need of mental health care necessitous? And they made a series of quite helpful observations. First was that necessitous is an ordinary word with no special legal meaning, noting in this case that the objects of the association clearly indicated an intention to establish a charitable trust. They said the court will prefer a construction that preserves the validity of that trust. And to be charitable, the purposes must fall within the spirit and intent of the Statute of Elizabeth. Now, we often see the statute cited in relation to the 4 heads of charity at quite a high level. But in this case, they actually went and looked at the wording behind the specific 4th head, in this case, other purposes beneficial to the community, and noted that it includes relief of the aged, the impotent, and the poor. They also commented that necessitous and deserving needed to be read conjunctively in these particular objects, and that it may denote an occasional rather than a permanent want, which I think is quite helpful and interesting to contrast with some of the requirements for PBIs. They said there's no reason to think it is limited to financial need, and and that a person could be necessitous of medical care, food, or shelter. I think really importantly, they also considered and distinguished Ballarat trustees. And Ballarat trustees has been quite influential for reasons I'll come to shortly. But they noted that in that case, a narrower definition of necessitous circumstances was adopted, which was really confined to financial need, but said that had been in response to the history of the relevant provisions of the then legislation, the Estate Duty Assessment Act, because that legislation had been amended in response to Chesterman to specifically replace the broader term charitable with a reference to necessitous circumstances. So although Ballarat trustees had this narrower financial need application, it really was limited to the specific history of the legislation in that case. Importantly, in that case, Justice Jeater said, the expression necessitous circumstances does not admit of definition in terms so precise as to provide a yardstick for every case, something that we would like the Australian Taxation Office to read carefully. In this case, in Barristers Benevolent Association, the New South Wales Supreme Court said the objects of the association allowed for a wider construction of the term necessitous, and that necessitous circumstances are those characterised by either necessity or poverty, with necessity allowing for consideration of these terms care, comfort, and maintenance. And if that was not clear enough, noted that it is not confined to relief of poverty. So coming back to the Statute of Elizabeth language, they noted again that reference to relief of the impotent and tied that to advancement of health and hence mental health care, finding that to be in need of mental health care is to be necessitous and deserving. They also made some helpful comments along in relation to the requirement to be for the benefit of the public, noting that barristers and their dependents are properly described as a section of the public, and in this case, a section of the public that adheres to a common calling and has a central role in the administration of justice and advocating for the community, including vulnerable members of the community. So there really was this potential for wider benefit that satisfied the court, that not only was the requirement to be necessitous met, so was the requirement to be for the benefit of the public. The term necessitous, as we know, also comes up in the context of necessitous circumstances funds, which are discussed in the ATO's taxation ruling 2009/6. In that case, or in that taxation ruling, the ATO expressly says necessitous circumstances refers to financial necessity and does not extend to needs generally, and they rely on the case Trustees of the Indigenous Barristers Trust. Sorry, they say they rely on Ballarat trustees to say that trustees of the Indigenous Barristers Trust should not be interpreted as extending beyond financial necessity. They say, insofar as the comments in Indigenous Barristers Trust, which attempted to expand the term necessitous beyond financial need, could be taken to imply that needs such as suffering, helplessness, misfortune, or disability constitute necessitous circumstances independently of financial necessity, they are considered to be inconsistent with the approach of the High Court and Ballarat trustees. So the ATO essentially said, notwithstanding the previous decision of the Federal Court, we're going to stick with the High Court approach in Ballarat trustees, which we think warrants a narrow definition of necessitous circumstances. In my view, and fortunately also in the view of the New South Wales Supreme Court, Ballarat trustees left the door open for a broader understanding of necessitous circumstances, not limited to financial necessity. And the Barristers Benevolent Association supports the proposition that the ATO's interpretation of the Ballarat case is too narrow. This really creates an opportunity for necessitous circumstances funds, if the ATO were to shift its position, to address much broader needs. And given that those necessitous circumstances funds do not need to meet the institution requirement, that would introduce significant flexibility with a vehicle that can raise tax-deductible funds to meet needs beyond financial necessity. I might hand over to you now, Myles.
Thank you very much. Let me just put up the slides. Okay, I'm on the Yagara people traditional lands today, and I pay respect to their elders past and present. I would like to deal with three cases today in quick order, given the time. One from the Charity Commission of England and Wales, and two homegrown Incorporated Association cases. The first one with the Charity Commission was that the Charity Commission decided that it would not grant charity status to this unincorporated association. There are its objects. Would you give it a tick if you were in the chair? It was to advance esotericism. There were various definitions of this, and the tribunal noted that even in the evidence that was given to it by the party, there were inconsistencies in it. And the term esotericism in the context of the objects means the broad category of belief systems that exist both written as well as independent of larger religious traditions and institutions. It's often distinguished from other types of religious behaviour through its focus on hidden or transcendental realities, on special or higher forms of knowledge, on non-ordinary experiences, on individual terms of spirituality and spiritual growth, and the efficacy of ritual, and would include such areas as alchemy, astrology, spiritualism, paganism, and druidry. The tribunal supported the commission and said it doubted whether this was sufficiently within the focus of the charitable purpose of education. They had the feeling that it provided a private benefit and would support persons engaged in private ritual rather than for the public benefit, of which there's a positive requirement under English law, which is different in education charity under the ACNC legislation and state legislation. The applicants also tried the plea that there are other registration decisions where you've let through organisations into the fold of charity, which are quite like this. We should be let in as well. The tribunal again said, that's not the right form here. It may well be that they've been let through, but notwithstanding that, it's not relevant to our merits decision. The tribunal was not satisfied that the purposes were charitable exclusively and ambiguously, and pointed to the conflict in what exactly the objects of the organisation were. Further, they said there's the private benefit taint, and we don't think that they're exclusively for the public benefit. So they were dismissed. In Australia, we would have a different law applying to this, because we assume in most jurisdictions that education is for the public benefit. The English law took a different trajectory with respect to this, and you have to affirmatively demonstrate that you are, in fact, for the public benefit. The Australian religion cases, New Faith and Commissioner for Payroll Tax, are examples of where the boundaries will be set. Just at the other end, you can also look at Bell and the state of Queensland, where Satanism was not regarded as a religion, and Watkins and the Commissioner for Corporate Affairs in South Australia, where Flying Spaghetti Monster was not regarded as a religion. The next one, and I'll move on, is Jeater and Swan Emergency Services Incorporated Association, Western Australia, a long-term member volunteer engaged in some unbecoming behaviour and was given a temporary sanction by the Management Committee under disciplinary proceedings. It was discovered that the rules under which that were given were not the current rules of the association, so that they had to go back and start fresh proceedings. Unfortunately, under the right rules, the only option was expulsion. During the reconvened disciplinary committee hearing, the volunteer offered an oral resignation, and this was later confirmed in writing in response to an email inquiry after the event that, did you really resign? And that was in the affirmative. I must note in this instance that the proceedings were in fact audio recorded and presented in evidence. I'm finding a trend in the cases that more and more disciplinary committees in clubs and associations are in fact being recorded, with the technical ease of doing so these days. But I wonder about whether people have actually turned their mind as the consequences of doing so, particularly in terms of consent and other issues if it does come to litigation. The volunteer had a change of heart shortly afterwards, and argued that the rules required any resignation to be in writing. He was in an emotional state, therefore it wasn't a voluntary resignation. He was hectored into it, and it was not formally accepted by the Management Committee. The court, the tribunal, looked at the rules and found that an oral resignation was in fact within the rules. It then, and this is the real pearl of this case, relied upon the Commonwealth Statement in Fatman and the Samoan Australian Congregation, which sets out a whole series of propositions drawn from the common law about resignations. And if you practice in this area, it's well worth taking this out and noting it as a guide. In that case, which this confirmed, the resignation is a question of fact based on the intention. It can be given in any number of ways, but the rules, unless it specifically states, resignations can be on other basis. And the other one to bear in mind, that once a resignation is given, there's no right to withdraw it. The things he had in fact resigned. The things I would draw as lessons from this case are recording proceedings. I would think you need to think very carefully about that, and particularly with consents. The importance of having the correct set of association rules. It's just, I don't know how many times I've seen disputes magnified and fester because you've got two parties with different sets of rules which they claim to be the one and only. Checking the independent source, which is usually the Incorporated Associations Registry, as to what has been actually registered as the final set of rules, should be on every checklist when dealing with disputes of this sort. And the judge also pointed out that there is an important function for associations to make sure that their current rules meet the needs of members. And here, I think he was inferring that it didn't meet the needs of members because all the disciplinary committee were left with was expulsion rather than some other sanction. The third case, and I'll quickly zip through this, regards a golf club which was a company limited by guarantee. A member was found to have engaged in conduct unbecoming a member. He didn't attend the first disciplinary committee but appealed, and then appealed on a whole range of grounds. And the judge goes through very deliberately each of these grounds. So it's a good case to look at the principles that were used. The major issue in the judgment was whether the reasons were needed to be given to the member in order for them to prepare and argue their case. And the court said no, although the member was entitled to know what the issues were. A reasoned judgment was not necessary because it was on the merits de novo and not an appeal technically from the decision. It also claimed insufficient particulars, that the complainants weren't known and they wanted to cross-examine them. It was also so unreasonable that you could never come to this conclusion again, which was not sustained on the evidence before the judge. And was there bias in that the material showed that he had no remorse and that he would reserve his legal rights to appeal. Again, the court found that didn't amount to bias. So the take from that case, at paragraph 43, there is a good statement, summary of the law about member expulsions, and it goes through the principles and issues in a very thorough but succinct way, which is great for lawyers to have at their fingertips. And the other principle here in this case is that the courts do not have a merits review. They don't hear the whole thing again. It's really a matter of were there any technical lack of natural justice or non-compliance with the association's rules, which would make this an errant decision. And of course, as I've mentioned, the no obligation to give reasons in the particular case. So Sari, I think I'll hang up my slides there and allow some time for questions.
Oh, thank you so much, Caleb, Myles and Beck. I'm just going to see if I can get my screen up so that the cases that you've each mentioned, you give me a thumbs up, Myles, if you can see that. Can you see? Yeah, thank you. Thanks, Beck. And then the third slide, which is at the end of the slide pack, is there's a QR code where you can see all of the wonderful case notes kept by QUT, ACP and S and their work in this space, if this has whet your appetite for looking at more case law. But while people are thinking of any questions, and I'm looking, I did have a quick question for Beck about the Montessori case, and I'd just be curious to know what was the nature of the context pre-2019 that you talked about, where the activities hadn't quite, demonstrated the requisite amount of activity, and you indicated they might have been more passive.
In some ways, I think the case is a bit unhelpful on this point, because pre-2019, they didn't have to make a decision about whether it was an institution or not, given that the relevant transactions took place. I think the relevant date was 2020. So that they weren't required to consider it, but they did hint that it might not have been active enough in that period. So just looking back at what they were doing, when they were first established, so between 2005, when they were set up, and 2009, it says the trustee established Montessori early childhood classrooms and curriculum through a number of islands in the Torres Strait, training local facilitators. Between 2005 and 2013, the trustee also engaged sponsor facilitators for Montessori-style education programs throughout Cape York. As well, the trustee supported a foundation in the Lockhart River area of Cape York. Now, I would have thought that the supporting of a foundation, yes, is passive, but the other activities described seem to me to have been active enough that it might have been in with a chance to be an institution pre-2019 anyway. But in any event, it says at the end of 2019, the trustee shifted its focus and activities to increase its direct activities. And everybody seems to have agreed that post-2019, those activities were sufficiently direct to constitute an institution, once you put aside the sort of perhaps red herrings that the Queensland Revenue Office was focusing on about having the right number of members and so on. It's a little bit of an unsatisfactory decision in the way it's written up, because even the composition of the membership is not set out very in any detail at all in the decision. So you'd have to go back to the earlier decisions to see what they were taking issue with in the SRO, or in the Queensland Revenue Office, I should say.
Thanks so much, Beck. And that was all the cases that have been discussed are really interesting, and the conduct cases, particularly the one that you mentioned, Gary Mond, Caleb, and the last case you discussed, Carmody and Roseville Golf Club. Thanks, Myles. There is a comment that Rosemary Langford has made in the chat. I don't have a question, but I agree with Myles about the need for care with minutes. Just double checking, no further questions. If not, I'd just like to mention before we thank our speakers that we do have the conference coming up in July. It will be held in Sydney, and we'd really love to see you there. We have heavily discounted tickets for people who are members of CLAANZ. So if you've joined this webinar and you're not a member of CLAANZ, we'd really love to see you at the conference and welcome you to it. In the meantime, I'd just like to say thank you to each of you, Caleb, Beck and Myles. We can't deliver these webinars for free as we do without your support. And I just really appreciate it on behalf of the Board of CLAANZ and all our members. Thank you so much for contributing to the knowledge and administration of charities. Thank you. And now you will be able to return to the rest of your Monday.